May I, Your Honor? Your Honor, I would like to mention for the anticipative bail in the Nyadotao versus State of AP, Your Honor. The matter will be heard listed, Your Honor.
Today?
Yes, Your Honor. Your Honor, I'm a public servant, serving as an inspector in Likhabali police station, Your Honor. And if I'm apprehension of
Vacation court?
Your Honor,
Do not have vacation court?
No.
Who's on vacation?
No, we don't have.
Not a single day.
No, I think we'll do, except for the Guwahati.
Make it faster. Tell them to make it faster because I'll be leaving.
Allah, sir.
Well, the procedure which the learned court below have adopted in this manner, in this case is very unfortunate. Well, just I take to the copy of the discharge, you know, which page is this?
Discharge.
Well, kindly come to page 31 straight for a moment. Something which my lord will also consciously not permit them to do this manner. Well, what page 31. Well, kindly see there is order is 49, 49, my lord. Case record is put up today, which is received on committal from the Court of Learned CGM SAPA. Accused person, namely Devada, who is produced before this court. Learned Counsel A. Lamnio has appeared for the accused person by filing Wakalan Estate representatives. I have heard Learned Counsel appearing for both the parties, and they have agreed to hear the charge today itself. At least this is something, and then leading to the discharge. Well, only issue notice, no?
Yes, we'll have to issue because
Only issue notice, yes.
PP has accepted notice.
No, Your Lordship,
We have served you the notice.
that's the petition. The
Yes.
notice as formality has to go, Your Lordship.
Okay. Mr. T. Counsel for the petitioner, issue notice to the respondents to register post with AD returnable within 4 weeks. List accordingly.
Your Lordship is calling for the scan copy of the LCR in this matter, Your Lordship. LCR.
It's not required for the right. 376 and 448.
LCR.
He may require.
Yeah.
LCR makes.
Scan copies of the LCR.
No, but it is discharged. The case is closed. It is interlocutory order. So therefore 397,401.
CD will come, maybe she will require to go through the CD.
No, that's why.
We have amended everything.
No, well, we have not appended, but court below record is required. LCR may be called. for.
Therefore,
Scan
Scan copy
copies of the LCR.
Scan is not required. Original can be called for.
the same. the
Discharge,
same
we can call
PSN.
for the original,
Original
call
discharge.
for the LCR.
Yeah.
Discharge. So we can call for the LCR.
Other side? No.
LCR, not
LCR.
scan copies.
After
4 weeks.
4 weeks. After 4 weeks. Next. Well, this is also something very unique. This, well,
What
let-
about 11?
11, call for 11. No, 10.
No,
LCR for
that
10.
was for 10.
Well, let me explain in this manner.
Um,
There was a land dispute with the community and the petitioner here. Then there was a kava. The kava decided title in my favor. Now the kava has two things. First, the village label, then the circle, which they interblaze kavang in the Adi community.
Appellate authority.
Yes, as per that section 3, which has been defined as a customary. Now here what had happened, here the first respondent is a society registered under Society Registration Act 1816, and it receives some sorts of financial aid from the state government and various organizations. So it comes under the definition of Article 12 of the Constitution in forms of other instrumentalities. Now, under this particular wing,
Which one, which respondent?
one, this Adi Banekal. So then what happens is that the telefilm judgment is very clear, Milord, on this. So now, under this organization, there is a wing called Bogang Bokang. My lord will kindly come to page 12.
Mm.
Bogum Bokang. Huh? 1, 2.
Mm.
So this is Bogum Bokang Kamang.
Mm.
Now, my lord, judicial wing of ABK. Now, this Adi Bane Kamang, my lord, is considered to be the apex social body of the Adi communities in Arunachal. So under these Bogum Bokang Kawang,
Page 12.
page 12, Milord.
Which
72. And 72, Milord. Sorry. I misread the essence and page 12. It's 72, Milord. So what had happened is, Milord, kindly see the letter page.
Mm.
Bogum Bokang Kawang. Next line is judicial wing of Adi wing, judicial wing of ABK. The traditional apex something, Supreme Council of the Adis. Now that they established 90 registers, so and so. Now what had happened? The title of that land has been decided in my favor. Now the next forum under the AP Civil Code is the interpolation. Now here the private respondent number 3 and 4, without my consent, have filed appeal before this forum. And this is a non-existing forum in accordance with the law. So therefore, any decision passed by this Bogam Bokang Kawang will have an evidentiary value since it has a social sanction. So therefore, will create some source of right for the private respondent number 2 and 3. Because they have interpolated my signature, fraudulently filed that appeal before this forum. And this forum judicially cannot take up that appeal. Either it has to be before the interblades as per section 2. Yes. So now, recently, in the same case, the order passed by this this Bogum Bokang Kawang has been interfered in one of the matters.
So you are submitting for interim
Yes.
order.
Yes. This court has stated the decision rendered by this Bogum Bokang.
Already a similar order.
Similar order. Same order.
Because this appeal before this Bobung Bokam is not maintainable.
Not maintainable. Therefore, unless that's one paragraph I have written one judgment. Kindly come. That is the reason why we have to say this.
So you must show me the law.
Yeah, kindly come
AP, this Civil Courts Amended Act,
yeah, it is already.
AFR amended part.
Not
Just show me. I
Well,
cannot
before-
remember.
Yeah, before this, kindly come to page 15 of my read petition, civil revision.
Page 15.
15, paragraph 19.
Yes.
That the impunged decision, although made in law, but will have bearing on the rights of the petitioner over the land in question. The Bogum Bokang Kawang is a judicial wing of Adi Bane Kawang, the apex social body of Adi tribe being a racial organization. Any wing of ABK passes any order, whether good or bad, in law, it will have a bearing of evidence before any customary court. In this context, it is relevant to cite the decision of Honorable Supreme Court of India in the case of Deepak Agro Foods versus State of Rajasthan reported in 2008, 7 SC 748, wherein it is held that all irregular or erroneous or even illegal orders cannot be held to be null and void unless it is cured through a judicial process. Well, that will have, that's why the evidentiary value will be there. Now coming to that act, you have extra copy. Yes, both copies we have to publish. And give me that. Oh, it is the same copy. Where is another that amended one? This is amended one. Huh? Got it. Malad will kindly come to the definitions. Straight two. Two D.
Amended Act.
No, Malad, that 12/2021 first principal act.
Okay. 2D.
2D.
D.
D for that delta. Customary code means court of traditional council or authority of a place indigenous to the state by whether name called and includes a court of village authority on the so and so. That governor is there. This we need not to listen. So now Manoj, kindly see 3. 3E. 3E.
Yeah.
3E.
Customary. Code.
Customary code. So now what happens is, my lord, after that, what happens? Kindly come to section 15, straight.
15(3).
Yes, 15.
50.
15 appeals.
15 years. 1/5.
1/5. My lord, kindly see 3. Appeals from decree or order passed by a court of civil judge. This is incomplete one.
That much I remember.
Yeah. So then, that,
I remember.
Yes. So, earlier what was happening was that 1945 regulations,
But this has been amended by 2022 Act.
2022 Act. So therefore, that customary bango level in Galo it is bango. In
But
Adi it is called kawang. That is.
okay.
No,
So then this is not the appellate authority. It can be the appellate authority. No.
No.
So which one is the appellate authority then?
Appellate authority will be that civil judge.
Huh?
Civil judge.
District judge.
This yes. Now it is a junior division from the village
No.
authority. From the village.
Amendment Act 2022.
Yes, yes.
4. Inter-village territorial and appeal from the village authority if agreed to by the parties shall lie before the inter-village
Four.
territorial
Yes.
customary court.
Correct. Customary
So
code
this
is
is,
that.
I do not know whether this is the inter-village territorial authority.
No, this is not the one. This is a judicial wing of a registered NGO.
So which is the inter-village territory that all Arunachal Pradesh?
Yes.
Only one.
This
Gamburaburi Association, only one.
in our there are lot of things, my lord. We Nisis, we do not have the inter-village village authorities. Similarly, the Apatani also does not have. But this Adis and the Galos have the very unique thing. First, they will have Bango village authority. Kaba they do it. Then they Bango means inter-village. Suppose.
So this is Bango.
This is not, yeah. But this judicial is not, this forum is not the Bango. It has to be headed by a Gambura.
A head Gambura.
Head Gambura.
So you do not have a head Gambura here.
No. It is a judicial wing. May not have seen page
Page.
72.
Page.
72. Bogum, Bokang, Kabang.
So where is the definition for inter-village? appellate
As per
authority?
the AFR.
Huh?
As
As per the AFR, where is the AFR?
that 1945
Yeah,
regulation.
45. Can you give me?
Volume of-
And that is also amended in 2000.
That's why further this AP code has been brought into for this reasons.
Page 72. There is no head Gambura.
No Gambura. It is a persona non grata. No?
GB. Number 1 GB, number 2 GB.
Hmm.
There's one 8 GB. Laben Jerang, number 9. Page 73,
7.
number 9.
But they were just members. They were members only. As an arbitrator, what is defined there?
Without going into the without going into the maintainability, how you will be prejudiced if I won't pass an interim order?
It will have a bearing, Lord.
Uh,
Say, for example, the fact is,
mm,
Adi Bade Kewang
mm,
is a registered society considered to be the apex social body of the Adi communities. Now, under this particular NGO, there is a judicial wing called Bogum Bokang Kawang that my lord has seen at page 72 on the top. Now, the question that is falling from my lord is whether this is a village authority or not. Respectfully, it is not. The village authorities under 1945 regulation and subsequent guidelines under section 5 of that 1945 regulations, the Ganguras are appointed. GVs. And these GVs are the village authority. This is only a wing under a registered NGO. Now, power cannot be exercised by this NGO unless or otherwise the civil.
which paragraph of your petition? Which paragraph of your petition?
Kindly come to page 15, para 18.
Para 18.
Para 18. That it is to state that Samis that the Arunachal Pradesh Civil Code Act 2021 and AFR 1945 has recognized the inter-village authority as an appellate court against the decision passed by the village authority. In the instant case, Bogum Bokang Kabang, a judicial wing of a ABK, a registered society, has overstayed the jurisdiction of the village as well as inter-village authorities as provided under the AP Civil Code 2021 by illegally holding a kabang, thereby passing the impugned illegal kabang decision dated 11/8/2023 by altering, modifying the earlier kabang decision dated 9/11/2030 by inserting word Ketin, thereby creating a right for the descendants of the Ketan subclass. This is the case. I was, while my brother brought this brief, I told him you insert this particular paragraph because the entire foundation of the case is this only. So, therefore, same thing, the same.
And where is the parity order you have submitted?
I have already
I think you have given it to me.
given. Yes. But the same forum, the order issued by this Bogum Bokang Kabang was interfered. Well, same order may be passed.
All right.
And
And where is the order you are agreed with?
that's page
Page 72.
72. 11/8.
So this order went against you.
Yes. Actually, what had happened was,
Plot of land.
yeah, title was decided in my favor by the village authority,
You are the sole
owner of the land.
owner of the land. You are fighting against the community.
Some plans were also there, but then that was settled.
Hard learner council Mr. Tuki Dara, for the petitioner. So and so, the petitioner has filed. This is an appeal or a
Civil
revision?
revision. Civil revision.
Yeah.
47.
Has filed an application under Article 227 of the Constitution of India against the impugned Keba decision dated 11/8/2023, passed by Bogum Bokang Kebang within bracket judicial wing of Adi Bani. You write this from paragraph 1 of the synopsis.
Normally, my paragraph 1 is always, I states everything in paragraph 1.
Convenient, everything is
Yeah.
there. Paragraph 1 up to the tick mark, huh? Not the entire paragraph. without jurisdiction.
Without jurisdiction, correct.
Whereas the subject matter. Okay, entire paragraph one. It is submitted that the order of this, the impugned order will have a bearing on the, which paragraph? We have stated bearing on the,
Para 18. No, para 19, Lord. That I have quoted the judgment of apex court. India, Indian.
on the evidence. Will have a bearing on the evidence.
Very bearing on the.
Will have a bearing on the evidence before any customary court. Full stop. It is submitted that the petitioner will be highly prejudiced on this instance. At the, it is submitted that the petitioner will thus be highly prejudiced. The petitioner has also cited the decision of this court in dated 28/6/2023 in connection with CRP number 32/2023, where in a similar matter, the impugned order was stayed. I have considered the submissions of the petitioner with circumspection. The petitioner has drawn out sufficient ground for any interim order. Meanwhile, issue notice to the respondents. How many respondents? 7, 8, 9, 10. All the entire community.
Oh, not community, they are
Yes.
individual persons.
Issue notice to the respondents through registered post with AD. The impugned order dated
11/8/23.
11/8/23 is state the returnable date. Huh?
After 6 weeks.
4 weeks returnable, 4 weeks, 6 weeks.
6 weeks.
Returnable is quite 6 weeks. Let it be more.
Grateful.
List accordingly.
Lordship, I'm very sorry, morning I could not able to reach due to vehicle problem. So I would like to mention one, that's criminal petition. That may be taken at last item. Yes, please.
May I please, Your Lordship? My lord, this is a CRP, my lord. By this CRP, we have sought for, my lord, setting aside in crossing of impugned order, my lord, passed by the Assistant Commissioner Ruxin, my lord. And we have prayed for an interim prayer also for staying of the same, my lord. Because, my lord, in a span of 3 months, my lord, 3 hearings were conducted, and this present petitioner, my lord, he resides in the remotest part of Siang district in a village called Yemsing village, where there is not even a mobile network, my lord. So somehow he engaged a council, but since there was no mobile network and July being monsoon season, they could not communicate with each other, my lord. In any case, my lord, this present petitioner has not been afforded any opportunity to defend his case. So in the next hearing itself, my lord, the ex parte execution order has been passed, my lord.
You're agreed by which order?
Page 51, my lord. Page 51. Page 51 is the impugn order, my lord. In fact, my lord, the execution proceeding which is pending there, my lord, itself.
Please read the impugn order.
Yes. Decree holder and learned counsel advocate Denjing Sanawal for decree holder present. Judgment that to remain absent without any letter of absence, neither his counsel present. Carries the letter submitted by the advocate Tony Dameng on 3/7/23. Only intimation regarding pendency of petition in Honorable Guwahati High Court, neither any order from the Honorable High Court attached, nor any petition number have been given. Moreover, advocate Tony Dameng have not filed his wakalatnama to represent the judgment debtor. Even wakalatnama was not allowed to file, my lord. They have admitted, my lord. The hearing was fixed on 4/4/23. Learned counsel for the judgment debtor, advocate Yon Father, was present and stated that the judgment debtor could not attend due to sudden road blockage in the Lelek area. The next hearing was fixed on 23/5, but again the learned counsel of the judgment debtor have requested for adjournment due to some inevitable fixed matter in the Honorable High Court Itanagar bench. And then again the hearing was fixed for today, but again the judgment debtor was absent, nor represented by his counsel. Ample opportunity have been given to the judgment debtor to plead his case, but judgment debtor have not attended due to such absence of judgment debtor. The matter is being proceeded ex parte. The judgment debtor is directed to make payment as decided in the Kabang decision of 12 May 2023 within 30 days from the date of receipt of this order, in default of which the judgment debtor shall be liable for civil imprisonment. So this present petitioner, he is from different district, my lord, and your lordship is very well aware that the connectivity in Arunachal is very harsh, my lord. So at least one opportunity ought to have been given, my lord.
Actually, I do not know his conduct also. Have you annexed, we'll see the LCR regarding his, regarding interim stay. I do not know his conduct. Maybe he was absent for several days.
No, my lord, because first hearing was only on April month. So April, May, June, within 3 months, my lord. Consecutive.
So how I will believe you? Have you mentioned it in the petition?
Yes.
How will I believe you?
Yes.
You ought to have appended the order sheets,
Original.
not original, order sheets of this record, certified copies of the order sheets of this record,
Yes.
for to affirm that he was absent for only 3 days.
No, my lord, because only Wakalat Nama even was not filed, my lord. The council.
Wakalatnama was also not filed.
Yes, he sought for filing of Wakalat Nama, because for filing of Wakalat Nama, he need to sign by the minor respondent. And this
Case was registered in the year
2023,
2023,
April 2020.
April 23.
Yes.
What is the case number?
Case number is 04/23/262, my lord.
This is an execution case,
Yes.
money execution,
Yes.
money execution. So you will have to pay the amount, deposit the amount if you are willing to stay. If you are asking for interim stay, you will have to deposit the amount. So we'll call for the LCR. We'll call for the LCR then,
Yeah.
without interim stay. Otherwise, you'll have to deposit the amount. How much you have to deposit?
50,000 only. In fact, my lord, the execution proceeding which is pending itself, no execution proceeding can be made of, because my lord, without any jurisdiction, my lord, the execution proceeding itself is illegal, my lord, without the jurisdiction. So if we are allowed to contest the case, my lord, even they cannot make out a case of execution, my lord. So
50,000.
yes, 50,000. Because this present petitioner, he's a bedridden old man.
Under section 115 of CPC and
227 of the constitution.
and order.
Only under section 115 of CPC.
Have you mentioned in the petition that you are bedridden?
Pardon.
Have you mentioned in the petition that you are bedridden?
Yes, ma'am.
You have
Even
mentioned
I
which
have
paragraph of the petition?
uh,
Have you given any supporting documents?
yes, my lord.
Medical certificate?
Yes, my lord. Yeah. Annexure 9, my lord.
Just,
Annexure 9.
just
And that too, my lord, is staying in a.
1 minute, just a minute. So this order was under execution proceeding.
So, my lord, my plea that.
How can you say that this court has no jurisdiction to execute?
Yes, my lord, because basically, my lord,
Under 115, you can come only on that ground. Let us issue notice. Stay cannot be considered now.
lordship,
Without
because
relevant documents. Let us issue notice, short date. I'll give you a short date.
lordship, in any case, my lord,
No,
the
how?
validity expire on
These
27 of
documents
this
are
month.
not- Sorry,
Validity expire, my lord,
what
on-
expired?
27 of this month, my lord. So
What?
on 27 of this month, the
27 of
validity,
this month, what?
yes, validity will expire, my lord.
Validity. Of what validity?
Because the petitioner has been directed to deposit the amount within 30 days, my lord. So
30 days, you pray for some more time. I do not know whether this court does not have jurisdiction or not. I'll need some more supporting, substantiating documents or anything, whatever you have.
lordship,
At least
unless
I'll need the LCR.
lordship, unless there is a temporary restraining order, my lord, they may price for civil imprisonment, my lord. So nothing will be left then, my lord, to be decided. I will plea, my lord, at this stage. Let the execution proceeding.
You are pray for time. You are given 30 days time.
Yes.
Pray for time.
So 30 days expire on the 27th of this one, my lord. So this is vacation, my lord. There is no court event, my lord. That is the process.
There is even better reason. For the judgment, if shall be liable for.
My lord, my plea is that
Without distress warrant, how can you be sent forwarded to civil imprisonment? A warrant has to be executed. How will be forwarded to you? Take time for 1 day.
lordship, because our plea is that let the execution proceeding be disposed of in its own, but at least opportunity to contest the case would be, my lord,
We
afforded.
need
my-
the CR, at least LCR will need last day of this court. Let's see, LCR at least is recorded. How will I know that this is an execution proceeding under section 21 of the CPC? So against the order, which way you ought to have come here? But you have resorted to section 115 CPC.
This is execution proceeding is not under CPC, my lord. This is under amended provision of AFR.
But you have to follow the spirit of AFR. You'll have to follow the AFR has to follow the spirit of CPC.
Yeah.
Uh,
But in any case, my lord, at least till returnable date, my lord, interim may be considered, my lord, because within a short span of 3 months only, the intention is, my lord.
This assistant commissioner
Yes, assistant.
is the appellate court.
Yes, ma'am. Executing court, ma'am. As per amended,
He was the original court or the appellate court.
is the
See,
executing.
I'm so vague about it. I'll need the record. I'll need the record.
Lordship, still just my lord, interim temporary protection maybe, my lord.
How come?
Because in
This
absence.
person, this assistant commissioner,
Yeah.
he is dealing with the original matter or the Kebang appeal.
No,
It's a
no,
Kebang appeal.
no, my lord. Only execution matter he can take up as per amended rule of AFR. ma'am.
As per amended AFR.
Yes, ma'am.
Please let me see the amended AFR.
Sorry, my lord, I have not.
Heard Mr.
And Pada.
and Pada Learned Counsel for the petitioner. The petitioner has filed an application under section 100 and so now you are blowing hot and cold. Now you're saying that he cannot take up the matter and now you're saying he can take up the matter. 1115 CPC, you have come under 1115 CPC because he has no jurisdiction. Now what to do?
Lordship, in the execution proceeding will contest that part, ma'am. But we are not been afforded even to contest the case, ma'am.
Another counsel for the petitioner, who has filed an application under section under Article 227 of the Constitution of India and section 115 of the Code of Civil Procedure, seeking quashing of the impugned order dated 4/7/2023 in execution case number 4/2023 by 262. It is submitted that the petitioner was not aware of which page that impugned order. Order at which page?
Page 51, ma'am.
The petitioner was not aware, or the petitioner was unable to appear before the executing court due to what?
Ill health.
As he was not well, seen the medical documents and marked as annexure 8. The petitioner was also not aware. The petitioner was also unable to file an okalatnama to be defended, not to be defended. The petitioner was also unable to file an wakalat number due to the road condition
Yes,
and due to landslide,
yes,
Huh?
road blockage.
road blockage. Due
Landslide.
to road blockage. Have you mentioned it in the petition?
Yes,
Which paragraph?
road blockage, my lord, part is not mentioned, my. But in the order, in their order itself, they have my lord reflected.
Mentioned,
Yes, my.
which is reflected in the impugned order
Yes,
dated
Yes.
4/7/2023. In connection with the execution case mentioned above. It is also submitted that the petitioner is at present bedridden. You have mentioned it in the
Yes.
petition. Which paragraph?
Paragraph 10, my. Paragraph 10 of my reflection. May I read, my lord?
Not required. And the petition resides in a remote far-flung area. Stop. The petitioner was given only 1 month time to pay the decretal amount.
Yes.
It is submitted that the petitioner may be forwarded to civil imprisonment if the forwarded for civil imprisonment if the order is not stayed. Issue notice to the respondents, call for the LCR. Till then, no coercive action to be taken. I'm not staying it. Huh? Call for the LCR, yes. Issue notice to the respondent. Automatically, it will get stayed. I'm calling for the LCR. No coercive action to be taken till then. List the matter on give a date. 4 weeks after, immediately after the vacation. 8 of November. Registry to register post.
Yes.
Notice to respondents to register post with AD.
Obliged.
Your lordship, this is the bail codes,
Ah.
wherein 482 is filed, because I has to be filed under a particular provision of law. There's no
No,
such
usually
provision.
over there in the principal seat, one I is filed connecting the disposed of bill matter.
But my lord, there has to be some provision, my lord, in my
So
humble
how
submission.
we cannot interpret as a part heard matter, no?
No, it's
a
not
part
part.
heard
of-
matter.
I'm praying for exercising of inherent jurisdiction of this honorable court in the end, for the ends of justice.
But I think, I was a proper way to file because over the
Just for reference,
that notification.
just, no, just for reference, there is a, even Honorable Appeals Court upheld the judicial. That
Of
next judicial propriety of same coordinate bench,
Okay.
any other, but this court, this bench also have similar jurisdiction. It can modify, this is also only for bail, modification of bail order. Not for dissenting with the bail order.
Yesterday it was too late to connect the VC. Otherwise, we would have connected the
My lord, I have
VC.
shown, yesterday this applicant here underprivileged persons, my lord. These underprivileged persons sometimes needs the assistance of lawyers, my lord.
So under which sections you have filed this petition?
482.
Yesterday evening, he came and told me that it won't be possible to connect the VC.
Yes, this is,
Such a short
this,
notice.
this honorable bench can take
At
up
least
the
in the
matter.
morning, if it was decided, then he could have connected the VC. Within such a short notice, it was not possible.
The two conditions, my lord, which I'm praying for modification.
Under which sections?
Sorry, my lord.
Hmm.
Page number 11,
482, only 482.
48.
Let's see, 482. Then you can withdraw and file an I if possible.
My lord, in my humble submission, madam, if,
You do not have a vacation court.
no,
That is the
if
problem.
this was an order by a magistrate, then there's a specific provision, section 439, but there's no such provision under the CRPC. The only,
No, IA in connection with. Also, you are saying that filing the IA is not correct.
not correct, in my view.
But over there, principal said, this is done. IA is filed in connection with that original case.
Yes, that should be in IA form. This should be not, if, in petitioner invoke 482, that means he's going out of track. And press for new relief.
Right.
Not maintainable.
482 won't lie.
My lord, that IA has to be filed under a particular section of law. madam.
No. You can file in connection with that original case.
Yes, but that, while considering that IA, this court exercises jurisdiction under 482, inherent jurisdiction. madam. If it was an order by a magistrate, then 439, yes, madam, an application can be filed under section 439. There's specific
But
provision.
coordinate bench 482. We are talking about a coordinate bench. A coordinate bench has passed this order. And how come under section 482, we will invoke only inherent jurisdiction? I do not think so. You can withdraw and file an IA. If you have time to, sufficient time, you just change the section and file the IA.
Today, madam, we don't-
Yes, if you can.
All right, madam.
You withdraw this. I pass an order, so you file an IA. What do you think? What do you have to say?
Yes, that will be the
Hmm.
option.
You know, if you have time, you file the IA, or otherwise during
Because-
session.
Even this is a disposed method. So if any changes, modifications, if once, then I can lie,
Sufficient ground also. This person is from Assam,
No, madam,
so that is why they are asking for government security. This person is from Assam, he is not a local resident. The government security, why it was ordered, is the reason is that this person is from Assam. So you act fast. Don't hold me back after 2.
Okay.
Petition is withdrawn. The learner, you can go. The learner counsel for the petitioner has paid for withdrawal of the petition. Third learner will be T. Gallo.
G Tato.
G. Gallo. Matter is closed on withdrawal.
Problem.
This is a joint application filed by all the victims, alleged accused, on the basis of compromise. So Lordship, this matter is of 2013. When the incident took place, immediately after the incident also they have compromised and the matter was approached before the Indian judicial magistrate. I have annexed that order also, submission of that representations for withdrawal of the criminal case. And also all the medical expenses.
They are
They are in fact
accused and
diverse. They are
complainant.
same, they are belonging from the same locality,
joint petitioners.
joint petition.
Accused and complainant
Yes,
and victim.
and victim.
Registered
All of
under
them.
sections
Lordship 326 and
440,
450,
52 and 326.
452 and 326.
You have submitted agreement.
Agreement I have submitted, Lordship. I have annexed
This
it.
case was pending at which stage?
CGM Teju, Lordship.
No, at which stage?
Lordship, this is fixed for appearance on 17 of this month. A few days ago.
Yes.
Yes, your lordship, the FIR is of 2013, your lordship. And
Yeah, we'll need this is a long pending case. We'll need the LCR.
Lordship, in the meantime,
Yes, joint petition can be stayed. Yes.
Okay.
They're willing to compromise, we can stay.
Lordship.
Yes, what do you have to say?
Wakalanama and affidavit may be written. Otherwise, I cannot file it.
Okay. I would liberty to file another petition. You want a Wakalanama?
Wakalanama and affidavit may be written. No, it is done, my lord, when petitions are withdrawn, my lord,
Hmm.
with permission of court.
But the petitioner is not withdrawn the wakalatnama.
No, my lord,
You want to
wakalatnama may
withdraw?
be returned to me
And
so that I can
affidavit.
file afresh. Wakalatnama and affidavit.
All right. Wakalatnama, the learned council has prayed for withdrawal of his wakalatnama and affidavit.
No, wakalatnama may be returned.
The wakalatnama and affidavit may be returned to the learned council.
Okay.
Yes, your lordship, call for LCR, your lordship, fixing the matter of
Let
Stage.
proceed.
yes.
Heard Mr.
J. Ginny.
J. Ginny,
Ginny.
learned counsel for the petitioners. The petitioners are, which one is the accused and which one is the?
Lordship, I'll-
Petitioner 1 and 2 are the accused, your lordship, and petitioner 3 and 4 are the victims.
The petitioners 1 and 2 are the accused. And the petitioner 3 and 4 are the victim and the informant.
No,
Informed.
both of them were
Are the
victims.
Victims. In victims. In connection with. GR case number 57 of 2013
Lordship.
arising out of. KUPS case number no,
57 of
57.
2013.
both the cases are 57.
Same.
Yes, your lordship.
Same.
57 out of 13. Registered under so and so sections and charge sheet number. No, charge sheet number. No. Both the petitioners have amicably settled their dispute and they are willing to bury their hatchet and compromise this case. Not Ms. T. Jenny, learned additional PP for Arunachal Pradesh for the respondent. Call for the call for the LCR.
Scan copy of
State-
here, sir. Scan copy, your lordship.
Call for the scan copies of the LCR for the proceedings of GR case number
57.
57 of 2013.
13.
Is stayed until further.
The-
List after vacation.
4 weeks. Sir.
Lordship, may I may I plead, Lordship? This matter, Lordship, kindly see this, before I'm reading I read this impugn order, this page number 21, annex number 5. As per this land dispute matter, as per this order, the EAC cum executive magistrate has already passed the final order.
Hmm.
This order has been passed at the direction of Deputy Commissioner, Itanagar Capital Complex. I'm reading that this operative portion, kindly see page number 22, page number 22. In view of the above fact and circumstance, the case, it is adduced that the plot of land where the septic tank has been constructed in is under the position of Vincent Dorji without any allotment order. And it shares boundary with the occupied plot of Yorum Tari, this petitioner, to the east and Navam Loki to the south and the Colony Road to the west, and it appears pragmatic to construct a protecting retaining wall to evade further decays and prospective collapse of the aforementioned septic tank. It is also found inexpedient on the part of the Mr. Vincent Dorji to have constructed a septic tank without obtaining allotment for the same from the competent authorities. Therefore, in view of the above factor circumstances in the case under relevant section of 147 of CRPC, this court direct the respondent Yurum Tari or any other member of his family to restrain themselves from disturbing the complainant and her family from constructing of the protecting retaining wall. This court also direct the complainant not to undergo any kind of construction in the plot of land where septic tank is constructed until she obtains land allotment order
for the instant plot from the competent authority and obtain construction permission from district magistrate. Further, the officer inserts Simpu of police station is directed to take necessary legal action against the respondent, Urumtari or associates and the complainant, that is Sangmo, Mrs. Sangmo and associates, if carry out any kind of art cutting or construction activity inside plot of land from the competent authority. This is the case. This case, the plot of land where septic tank in question it belongs to me. This private respondent has constructed that septic tank over my land. Over that, this is a government land in which I have already applied for extension of my land allotment because this land is has been occupied by me. As per the relevant procedure of this land allotment, that is permissible. And this private respondent also applied for the same. That is why the executive magistrate come. This EAC concern has passed this order saying that until and unless land allotment order is passed in favor of you, either of you, you should not construct anything there. But this order has been passed on the direction of the deputy commissioner. But this page number 28 and actually
Let us say something.
yeah.
Maybe she want to.
Actually, Lordship, I'm applying this court, Lordship. Lordship, they have come this petition challenging the order dated 3/10/23, Lordship,
Yes.
which was passed by the deputy commissioner in the capacity of additional deputy commissioner, not
additional
executive magistrate, Lordship. So we cannot, Lordship, represent him, Lordship, as a DC. This can be represented by the government side, Lordship. And Lordship, moreover, this order, Lordship, has been, Lordship, replied by the Lordship, order dated, Lordship, on the last Lordship, last page 36, by the deputy commissioner. Lordship, may kindly see, Lordship, where it is reflected that your appeal petition is returning back and you may approach competent regular court for redressal grievances. It is not maintainable, Lordship.
Page which 26?
Page 36, Lordship, last page,
36.
Lordship.
There's no page 36 here.
Page
35.
35.
Already patak 35 then.
Page number 35.
Okay, appraisal of the documents is found.
Did the reply of the Lordship order dated reply of the Lordship, they are representation, Lordship, yes, Lordship,
Returning of appeal under 12 APP Act.
Lordship. Against this order 3/10/23, Lordship, they have approached the Lordship deputy commissioner by this appeal dated 10 October 23, which is again replied by the deputy commissioner dated 10/10/23, Lordship, itself, Lordship. The returning of appeal filed under section 12 of APP Act 2003, Lordship. So, Lordship, this petition not maintainable under 482.
No. That is why I am submitting those. Why this is maintainable. On that part, I wanted to submit this. This order has been passed under 133 of CRPC. 133 is generally passed in the public places. This is the place where order is passed is not a public.
Then you must
place.
file your petition.
Not a public places, but my occupied land. This is a private land. Belongs to government. This is the case.
They should
And
have come
over
under
that
the petition
disputed-
challenging
over
the
that
issue order,
disputed
Lordship.
plot of land, this executive magistrate has no authority to pass this injunction conditional order under 133 CRPC. And this 133 CRPC is not an appellable order. That is why I come before this honorable court for interference, because if this, as for this impugned order 3/10/2023, this ADC, what is DC at the direction of the deputy commissioner, ESC has already passed final order.
Some produce public
But
access eviction and.
This is not a, this is not a eviction case. This case is a executive order to do away the nuisance, public
Where is
nuisance.
the original CR? Have you
Nuisance
annexed?
complaint. This is a complaint. The private respondent has made a complaint under nuisance because they
We'll
are,
need the LCR.
that is the That is why this stay order may be
No, no
filed.
stay, no stay.
Because
to find
kindly
out.
say,
We'll need the LCR, we'll have to find out. Issue notice to the respondents to Western Coast with AD, returnable within 4 weeks, call for the LCR.
Lordship,
on
they,
the- on the
Lordship,
next-
kindly then, Lordship, DC
on
may
the
be made
next-
party, Lordship.
on the
Deputy
next-
Commissioner may be made. party.
on the next, that this my interim order, interim prayer may be heard. Lordship.
Okay, prayer for interim.
Yes, on the next day, please. When the LCA
interim
is,
protection may be heard on the next day, please.
yes. All right.
Agency,
Yes, Lordship, there
what
is,
is it?
there is a warrant of arrest issued against the petitioner. That's why.
There is an NBW
When
against
when
it.
was it issued?
It was issued on last date, that is on 27/9/23.
Long time back.
Long time.
You have survived so far. Try to
That's it.
survive till then.
Just 27/9, last month only. So there is a urgency.
27/9, 14 days.
27/9/23.
That's what I'm saying, 14 days,
Yes,
14 or 13 days.
Lordship, there is a urgency. It may be taken up as a last matter.
Cannot. She's right.
Okay.
Yes.
Deeply obliged. Yeah, please, my lord. My lord, this criminal petition is filed jointly by the complainant and alleged accused person as a petitioner number 1 and 2.
Complainant and accused person jointly,
Yes,
482,
482 for passing of FIR.
section
Section 324,
324.
324.
They said under section 324, 341.
Earlier, initially,
Charge sheet has been submitted.
yes, charge sheet has been submitted.
Stage,
In-
what is
in-
the stage?
Initially, my lord, initially the case was registered under section 341/326.
Now
But,
it's 320.
but after the investigation, IO has filed under
Case is pending at which stage?
is evidence stage.
Evidence stage.
Yes, my lord.
Any statements, any evidence
No.
recorded?
No,
Not yet.
not yet.
Let me see the FIR.
How do you-
FIR.
FIR. FIR, page 14.
13.
What?
Yes,
No,
they
no,
got it.
14, page 14. May I read? To the officer in charge so and so FIR. Sir, with due respect, it is informed you that on 24 April 2028, around 11:30 PM, I came out from my residence on hearing the noise and found that my brother has been severely injured on many parts of body, which was caused by a sharp weapon just near our resident gate, who was out for urinating. The accused person is now Sri Bulo Sambio of Kong Place, Lord Sponsori, presently who is residing at Barafani, Narlagan. There are
So you have annexed the, this medical report?
medical report, yes, already it is in the chart sheet. May I take my lord to page 25. Page 25. This is the medical report. As per the medical report, my lord, the injury is a simple injury. So IO has filed under
I'll read the medical report, huh? Lacerating of left, this left radial side of leg. Laceration and tendons. Left. Middle ring and little finger. Yes.
now, my lord, during the consideration of charge, 341 was dropped. Only 324 is
Yes, yes, PP.
and then
Yes, as per the petition document, last page, victim was already is no more as per the village report,
Oh, victim is no more.
no more. And this petition is moved by improvement, I suppose.
Yes, yes.
Improvement.
Improvement is sister of the victim.
When did the victim pass away?
He was after incident of 3 months after the incident.
Why did he die?
He's actually as per the
No.
statement.
We'll call for the CD. LCR. We'll call for
LCR.
LCR.
Says my lord.
Because there is an injury on his parietal area.
No, my lord. He's a low pressure patient.
Maybe we'll call for a CD, LCR. Heard Mr. Yes. what is his name?
Jitadi. Yeah, Jitadi.
G. Tadi, Learned Council for Commissioner, and Mr.
Jital.
G. Talo, Learned Additional PP, Arunachal Pradesh. If you notice to the, oh, you have joint petitioners.
Yes, yes.
A call for the LCR,
Scan copy.
call for the scan copies of the LCR list. Verification. Then allow the petition under section 480.
The lordship is the take the petition under section 482 for quashing of the proclaimed order, proclaimed notice issued against me. Impugned, this is in page number 21, your lordship. Annexure number 5, 20, page number 20. So before coming to the impugned order, your lordship, may I take your lordship to page number 23, annexure number 7 series. This proclaimed notice was issued without rendering any service of notice to me. This, your lordship, this case only after this proclaimed notice that a case is being registered and the charge sheeted against me. The case was registered in Dapurizo PS, Dapurizo, the police station, as PS Dapurizo PS case number, your lordship, in notice Dapurizo PS case number 15 of 2002 under section 376(34) IPC. I was never been arrested and never been informed. No, I have not been issued any notice to appear before the IO of the case. Then
You are shown as absconder.
yeah, I have been shown as absconder by the investigating agency.
And then
The
after
charge sheet has been filed.
summons have been issued, then you did not turn up.
I
because you did not receive
never
notice,
received the summons.
So without summonses have been issued, no?
This might have been issued. I have not.
You do not know.
I do not know. But from the order of the learned trial court, additional session judge Basat, it reflects that no service has been rendered. Your lordship, in page number 23 to 100, page number 107. Till that, entire order, almost that your lordship, all total 24 copies of order have been passed, in which in every order it has been reflected that no service has been rendered by the executing police authority. Your lordship, in the page number 23, may I read this portion? Needless to mention here with that, in the page number 23, paragraph number 2, last sentence. Paragraph 3, last sentence. Needless to mention here that without necessary service rendered by the executing police authority, no substantial justice could be delivered by the court. In entire order in annexure number 7, same order has been passed. Same in page number, your lordship, in 25 also, same sentence, same order. In every order, all the service has never been rendered, though series of warrants were issued against me and summons were issued against me. And your lordship, may I take your lordship in page number in the same annexure number, page number 23, in the 23 last paragraph. Police was directed to put minimum effort in tracing out the accused person and execute the fresh available warrant of arrest to be issued. In the event of not finding the accused persons at the given address, necessary inquiry shall be made as to whether accused persons are alive or not, or they have migrated and settled elsewhere. Whatsoever may be the outcome of inquiry to be conducted about the whereabouts of the absconding accused person, appropriate report shall be submitted to this court till next day, so as to enable the court to pass suitable order. Until the passing of the impugned notice, proclaimed notice, no any report has been submitted, no any service has been rendered, no service report was submitted by the police or executing police authority. I was never been summoned from the court, and on the fateful day of your lordship, 4th of this month. 4th of this month is October 4th. October 4th. I came to know that this notice has been issued, and that the same notice has been pasted in the nearby the office of the deputy commissioner.
Yes, your lordship, as per the state submissions being made, as well as his statement in the petition is totally contradictory, which I'll point out. Your lordship will come to page number 3, your lordship.
Yeah, I am coming to this, your lordship.
Page number 3.
Yes, your lordship. If I may read second paragraph, your lordship. The petitioner respectfully submits that a brief overview of the case reveals that on 21/10/2020, the accused petitioner came to know that the case bearing the Aporijo so and so has been registered against him. When the police personnel came to the residence of Sri Tau Main at Aporijo to execute a bailable warrant of arrest issued by the learned session judge Leparada on dated 28/8/2020. Now, your lordship will see since 2020, your lordship. And the same has been reflected in the order dated 2011/2020 of the learned court of session judge. The accused person was released on bail on 21/10/2020, your lordship. He has been participating in the entire process, your lordship. Then your lordship will come to page number 5, your lordship. The first paragraph, I'll start midway. It starts from however, your lordship. However, it came to the knowledge of the accused petitioner only on 21/10/2020 as aforesaid, and going through the order dated 23/6/2015 and 21/8/2015. I don't know, this must be a typographical mistake, your lordship. Passed by the learned court of session judge Basar, that the present case has been charge sheeted by the IO of the case without physical arrest of the accused person. Now, your lordship will see here he was granted bail. He has never cooperated, and therefore, in his absence, a charge sheet was filed before the learned court below, Your Lordship. Then Your Lordship will see at paragraph
May I
4.
finish, Your Lordship?
Wait, just let me finish. Paragraph 4,
I'm
Your
coming to
Lordship.
this, Your Lordship. Before I'm coming to this. I may be allowed to submit this. Your Lordship. Your Lordship, I came to know on 21/10/2020 that a bailable warrant of arrest was issued and it was executed, and the next date was fixed on 7/11/2020, in which I appeared accordingly. I have made this in my apartment also accordingly, but I, being the uneducated and the farmer and the village in the interior village of Upper Subansiri, I wrongly appeared before the learned court of Chief Judicial Magistrate Dapurisha, wherein I was informed that due to at that point of time physical court functioning court was not there due to national COVID-19. So I was advised that no court is there, no physical court is there. So and accordingly I went back to my place. Thereafter, after resuming the physical court proceeding, I was never been summoned. So I was not aware of the fact that court has been resumed, and notice I have not been received. I have not.
So
received.
what do you want now?
My humble prayer is that, Your Lordship, I want to attend after receiving this, after seeing the notice. I want to appear before the court.
What is your prayer?
My prayer is that, Your Lordship,
To quash the PNA?
Yes,
PO.
PO, not PO actually, proclaim order and the notice.
Proclamation.
Proclaim notice may be quashed, and I may be allowed to appear before the.
Yes. All right.
Yes, Your Lordship.
That much only.
Lordship will only, my submission with regard to this is that he has stated that he has not been summoned on any occasion, Your Lordship. Lordship will see bailable warrant when it was granted, he was arrested, same address, Your Lordship. Since 2020, Your Lordship admitted to the fact that there was COVID at that point of time, Your Lordship. Your Lordship will also see his own statement that he was much more aware. And if I may take Your Lordship to page number 20, Your Lordship. Is the annexure 5, Your Lordship.
Yes.
Is an order of 28/6/2023. Your Lordship will see the third paragraph. As per the record, warrants and proclamation have been issued against both the accused for the last 25 consecutive times, but to no avail. Since 2020, if the court were not sitting, there were no effective orders, Your Lordship will see as per their statement, Your Lordship. Since 2022, effectively when the court started taking up this matter, till 2023, 25 consecutive times orders were issued, Your Lordship. He till that time was sleeping throughout his.
That's why, Your Lordship, I am submitting that in lecture number 7 series.
All right, we'll keep those in abeyance. You appear.
Yeah, I am ready to appear
Alright.
before the
Yes,
Warrant
when
and NPW, everything will be kept in abeyance,
obliged.
and then trial
What-
court will grant you whatever it feels like.
Yes,
whatever
yes.
will grant you bail.
Yes,
in that regard, Your Lordship, my only prayer with Your Lordship is that a non-bailable warrant was issued against the.
That will also be kept. in
No,
abeyance.
yes, Your Lordship. Non-bailable arrest was issued by the the court below, Your Lordship. That may be kept for abeyance, Your Lordship, and his production may, since he won't be arrested, he can answer the proclamation issue to the court, making his presence and putting up his grievance, Your Lordship. The court will automatically, in that case,
Your Lordship, unless this proclaim
Mr.
K Gara.
K.
K Gara.
Gara, learner counsel for the petitioner, only one.
Yes.
There are two, but you are doing for only one.
One. Actually, there was two. One is already expired.
Oh. Learner counsel for the petitioner C. Tachung, Elias Nyachung Maing. And Miss T. Jini Learner additional fees, Arunachal Pradesh. The petitioner has filed this application under section 482 CRPC. Seeking quashing the impugned order dated 28/6/23, wherein NBWA and proclamation order was passed, and thereafter subsequent
Proclamation notice.
and also questioning of the proclamation notice dated 28/6/23. You have mentioned 28.
28.
28/6/28.
On the same.
You have time travel. Date is wrongly mentioned. In connection with Daporiju PS case number 15/2002 under sections 376/34 IPC. It is submitted that the petitioner had once appeared before the learned CJL.
Learned additional session judge Basar.
Or had once appeared on 7/10/2010.
On 7/10.
7/10/2020.
Yes.
7/10/2020. And he was released on. It is submitted at the bar, and he was released on bail as bailable warrant was issued against him.
Yes.
And the petitioner came to know that due to COVID, court was not functioning. And thereafter, the petitioner being an illiterate person, he did not appear, and he was not aware of the warrants being issued against him. The petitioner was the petitioner was struck it off. When did he came to know about the notice? On 4th.
On 20.
On 4th of this month, the petitioner learned that.
No, your lordship, if I may, your lordship, if those dates are not been given, your lordship, because his own statement has different sets of.
I will give
when-
you those, I'll mention about the dates later. But his submission is that he came to. know
Yes,
about
your
it on
lordship,
4th.
yes.
It is also submitted that on 4th of this month, the petitioner learned about the proclamation notice being pasted on the board of the
Office of the Deputy Commissioner, Daporiju.
on the notice board of the Office of the Deputy Commissioner. Full stop. Now the petitioner is willing to appear before the court and cooperate with the appear before the trial court and cooperate with the trial. The petitioner has thus prayed for quashing the proclamation order as well as the NBWA.
No, your lordship, only the proclamation order.
As well as the NB, just check it, as well as the NBWA. Illinois additional PP has raised serious objections stating that the petitioner was continuously absent from
He was continuously absent from investigation stage to till the last.
He was continuously absent from the stage of investigation till which is the order? Last
Because
order?
that's why I was pointing this to your lordship, that the last order they have annexed is only of June, your lordship. Thereafter, how many times the matter could have come?
28/6, huh?
Your lordship, I had mentioned.
Oh, May,
this
May,
in my para,
19.
I had mentioned how many days.
23.
In my para 4, I have mentioned
Yes.
on next date, para 6, para 5, I have mentioned And the next date was fixed on after 28/6 after impugned order,
26, 23.
21 and the 21/8/23, and the next date was fixed on 9/10/23. It is a 10.
23.
Next date was, last date was 9/10/23. No court was there.
Not required to mention the date. The
Yes.
petitioner was continuously absent.
Till date, your lordship.
From the stage of investigation till date, the case was registered on in the year 2020.
Yes.
And since then, the petitioner has not appeared before the investigating agency or before the trial court, the learned addition PP has prayed to dismiss the petition. I have considered the submissions at the bar with circumspection. The petitioner has pledged to cooperate with the trial. I have taken a pragmatic view. Just strike out, I have taken a pragmatic view. As the petitioner has pledged to cooperate with the trial, for my pragmatic view is taken, the NBWA is kept in abeyance and the petitioner is directed to appear before the jurisdictional court within 15 days and apply for regular bail, which will be considered by the court as per merits of the case. Meanwhile, the proclamation order will remain in force.
Yes, your lordship. Because then he can make an objection to
So
that.
jurisdictional court, magistrates court.
It's a session court, additional,
Second court,
additional
Costco case.
not 376 case.
376.
Case, charge, yes.
Oh, so trial has commenced,
Price, not yet, appearance stage,
appearance stage,
yes.
additional session. judge.
Since the accused did not come for this many years, the trial could not be commenced, your lordship, this stage.
Case was registered on, in 2002.
The proclamation order will also remain in force up to 15 days. Till then, till the trial jurisdiction court passes any order, the proclamation order will remain in force. Whatever she does.
Deeply.
Earlier.
May it pleases your lordship.
Yes.
My lord, office order may kindly be perused. And office order number 30, dated 38/23.
Office order dated
30/08, 38/23.
38/23.
Yes, my lord.
Office note.
Office note, my lord. It says that
AD card received
AD
in
cards
respect-
received on behalf of respondent number 1 and 2. Thereafter, your lordship order dated 19/7/2023. One Mr. R. Koyu has appeared on behalf of the respondent. And my lord may kindly peruse that. And then he submitted before this honorable, before this lordship.
Better to come
that-
up for
that-
admission.
Yes, and he will be filing his wakalatnama. So since he has not filed his wakalatnama, so his name has not been shown in the cause list, my lord. So my lord, I pray that matter be fixed on the next day, and I will do the hearing, my lord, even if he doesn't appear. And that may be noted in the
But
order
what did you submit just now? I'll fix a date
for admission hearing, my lord. And
Yes.
that may be observed that even despite he appeared on 19/17/23,
heard Mr. SK Singh.
BK Singh, my lord.
Huh?
BK Singh,
Heard learned counsel Mr. BK Singh for the petition
petitioner.
for the petitioners who has submitted that who has submitted that the office note dated 38/2023 clearly indicates that respondents have received notices, respondents number 1 and 2 have received notices and wakalat nama was to be filed, but several adjournments have been granted.
Not
to-
several, only two.
to-
On 19/7/23, he said, the council appeared and said that he will file wakalatnama.
Full stop, not but, you strike off but and several, full stop, on 19/7/23. Learned counsel, Mr. R. Koyu appeared for the respondents number 1 and 2. But thereafter, on the next date, the respondents were not represented, and today also the respondents are not represented. List the matter on,
My lord, 28
Or-
November, my lord, will be convenient to be met.
list the matter on 28th
28, 28
November for
November.
admission.
Highly about.
May it please your lordship.
Your
Lordship.
Lords, in custody of a vehicle, madam, which is seized, madam, by PS case number, madam.
Custody of vehicle,
Yes, madam.
NDPS.
And
No,
yes, madam.
yes.
This one, it was not because during investigation, madam, it is in the stage of investigation. We could not file a petition before the court below, madam, under section 410 or madam 457. Since Sijali has been produced before the land court below, madam. So as per
So
the,
under which sections you have filed?
now under section 482, as per our division bench judgment. Ram. And first.
You come straight away to the High Court.
Yes,
it can be.
that's the reason the maintainability, your lordship will see the previous
So the
order.
section 451,
On maintainability, a question was raised, which was to be argued today.
in last paragraph, madam, 45.
Oh, that order.
Yes.
order.
Yes,
Because during
You are
investigation,
pending for a long time.
yes, now it is answered in page paragraph 45.
But directly before the High Court.
yes.
Yes, it is in the, yeah,
There is nothing as
this-
such in
page 44.
paragraph 45. This is with regard to 451, your lordship, and 457, your lordship.
457,
Now-
if it is not, if it is not produced, now what does mean produce? In this judgment, this Sundaba,
I think it is maintainable.
no, I'll satisfy. Because in this case, Sundaba Amrat 10 SSC 283 was observed, was interpreted. Now, by way of under judgment of Sundaba Ambala, that was subsequent to this one 283. It says on what does production means. Also only one paragraph number 2. If the Caesar is produced, that is sufficient for production.
I
In
don't think this is maintainable.
Yes, your lordship will, I'll clarify to that, your lordship. My friend is pointing out to 450 Sundarbai Ambala case. The first case, it deals with only 451.
no,
You appear before the lower court first.
Yes,
I'll
After the
satisfy.
lower court rejects your petition, you come before this court under section 378(2).
yes.
No, my
In fact,
paragraph number 44 for a moment of our High Court judgment. Whether 482 is maintainable or not, it is
Okay,
answered in
paragraph number 42.
44,
Please
may I-
read it out there.
the fact that the Honorable Supreme Court has given a direction to the Rent Court, the criminal court to consider a release of seized property article as the investigation stage under section 457, so the 457 can be applied by the criminal court at the investigation stage for release of seized property. The submission made by the counsel for the appellant that the judgment of appeals for in so and so did not deliberate on the scope of 457 CRPC for granting custody of seized property at the stage of investigation cannot be accepted by us. While different situations and circumstances could arise in respect of seized property, one situation that can arise when the police submit a final negative report that the police authority failed to release custody of seized property in terms of a 102 CRPC. In that case, there would be no other remedy for the aggrieved person except to approach the High Court under section 482 or Article 226 Constitution, which should be a difficult task for people living in a far-flung area, those belonging to the weaker section of society. In that event, 457 would become redundant. After considering the decision of the apex court at the various high court along with 457, we are of the considered opinion that the words any such property is not produced before a criminal court during inquiry and trial. Appear in subsection 1 of 457 cannot be restricted to mean that stage of inquiry or trial is condition precedent for a court to have jurisdiction for exercising power under section 457 CRPC at the investigation stage. We are of the view that the words any such property not produced before a criminal court during inquiry trial appearing in section 47 CRPC would have to consider to be reference to a stage of investigation, not the stage of inquiry trial. Further, we are bound by decision of the appeals court in so and so in terms of section Article 140 of Constitution of India, as it mandate of the Constitution that the law declared by the Supreme Court shall be binding on all courts within the territory of India, also in the case of so and so. It has been held that the High Court cannot question the correctness of the decision of the Supreme Court, even though points stated before the High Court were not considered by the Supreme Court. In the
No.
Yes. In fact, this is totally against him. The honorable court is clear that if my lord, if he allows it, I'll clear the prospect even for him, your lordship. We'll see that Sundarbai Ambala first case, it was dealing only with 451. Now, subsequently, when a issue came into consideration in Sundarbai itself, that will the only submitting of the Caesar list will amount to bringing the property before the court, producing the seized property before the court. And it was only explained in the subsequent Sundarbai Ambala case. Now, why are these divisions bench order? Even our High Court has clearly stated that under 451, 457, during investigation, it can be invoked. Now, to my
So
even
not a petition.
yes, why am
And you apply for the,
yes.
when it will be rejected, then
No.
you can come under 482.
Yes. Now, if I
Wait a
may,
moment, my lord. Kindly see this Caesar has been produced before the court. In subsequent judgment of the Sundarbai Ambala.
This case is under investigation.
Yes.
yes,
Yes, so it was produced. Now, Lord Court will not give the custody of the vehicle to me because it was produced before the court. By way of a Caesar.
your lordship, that's why I'm saying
Then it will be
Sundarbai Ambala.
rejected.
Yes, Sundarbai Ambala case,
Then I
the
this judgment.
the judgment.
It won't be rejected.
Yes.
As per this judgment, it
Yes,
won't be rejected.
and the Sundarbai Ambala case, the judgment he has submitted, your lordship will see the last paragraph, your lordship, that it deals only with 451. In 451 case, if the Caesar memo itself is produced, it will be amounting to the production of the seized item in 451, not under 457. That there is wrong conception.
Hello, kindly see, however, under section 457 CRPC, the criminal court has the jurisdiction to give custody of the seized property article. as
Yes,
per
the criminal court.
investigation, when those seized property are not
Which
produced before the
paragraph?
court.
Which paragraph?
45.
Yes.
However, under section 457, the criminal court has the jurisdiction to keep custody of the seized property article at the stage of investigation when those seized property are not produced before this court. So the subsequent judgment of the Sundarbai says that if the Caesar list has been produced before the court, this amounts to
no.
production of the articles.
He, now if I may take your lordship to the,
The
if he's
subsequent judgment, paragraph number 2. In my case, this Caesar has been produced before the trial court below. If
So then,
I go there,
Ah.
then in view of the judgment, again the land court
if
below.
you go there in view of this judgment, you will be granted Caesar,
Hmm.
oh, sorry, custody of the vehicle.
I have to observe that.
How can I observe?
Then because I,
It will be
again, I
like
have to,
Hmm.
again, then I
Like
have to
nothing
come.
the court,
Yes,
huh?
he's-
Follow my order.
He's totally, your lordship is
Because-
totally
because-
confusing with
No, I'm
451.
not
What
confusing,
I'm,
I'm clear about it.
what I'm trying to say
Because it
is
was produced.
451, when do it comes? Inquiry and trial. 457, your lordship will see why 457 provision is provided. Whenever the seizure of the property of any police is reported to a magistrate under provision of this code, any such property is not produced before the criminal court during an inquiry or trial, your lordship. That is why during pendency of the investigation, 457 applies, your lordship. That was made clear by our own High Court, your lordship. Your lordship will also see it's very clear who is the criminal court. The criminal court having the
You will have
jurisdiction.
to withdraw this
Yes.
petition and you file before the trial court or whichever court jurisdiction. That'll be better instead of dismissing at the stage of admission.
What
And what about this judgment? What do
Yes,
you want to show?
in fact, I wanted to show that judgment was because of the paragraph number 8, your lordship. The effective paragraph is at page number 4, your lordship. Down below page is written, your lordship,
Hmm.
page number 4.
Hmm.
This is while dealing with a different case and the inherent power of the Honorable High Court under 482. If I may read the second paragraph, Your Lordship. At the outset, the following principle may be noticed in relation to the exercise of the inherent power of the court, which have been followed ordinarily and generally, almost invariably, barring a few exceptions, that the power is not to be resorted to if there is a specific provision in the court for the redressal of the grievance of the aggrieved party. So my only contention with regards to this was, there is a provision.
You're very
So
correct.
for under 482, it's not mentionable per se.
It is always there. There are several judgments, but this is a good judgment.
Yes, Your Lordship.
I'll keep.
Very
it with
specific.
me.
Yes, Your Lordship.
But it is produced by way of Sidali.
Hmm?
By way of Sidali, it was produced before the land court below.
You have the option here.
Yes, sir, now.
Through this judgment, even through this judgment. You better withdraw it. Instead of dismissing it. Learned counsel for the petitioner has prayed for withdrawal. Petition, heard learned counsel for the petition, Mr. R.K. Goswami, no?
As per.
Yes, Bhotagul. Where Bhotagul has prayed for withdrawal of the petition. Heard Ms. T. Jenny Lanan, additional PG of Arunachal Pradesh. Petition is dismissed on withdrawal.
It will be closed, my lord, otherwise, my lord.
Huh?
It will be closed.
Oh, okay, matter is closed, not dismissed, matter is closed.
Your Lordship, if the matter is being closed, Your Lordship may write an
He has
observation
already
with withdrawn. Your Lordship.
Yes, I would do it.
Withdraw,
That's why it is-
matter is
it will
closed. He doesn't want a dismissal order. You can keep this with you.
Yes.
If I may, Your Lordship, just as matter is closed on the account of withdrawal, Your Lordship.
Matter is closed on withdrawal.
Because on the next day, if they challenge
Yes,
coming,
in
there
fact,
will be
thank
no
you.
reason.
In fact, thank you.
Yes.
I have left out these few words.
Yes, deeply.
It's a real application of the.
Very.
In this instant case, just this case is to weaken the custodial assault against custodial assault complaint against this alleged accused. This is shown arrest. Main case is there in 136. If may I narrate the incident.
Where is the main case?
Main case, that shown arrest case is there in main case is page 20. If may, my lord, turn page 20. Page 20, that main case is 136 Naharlagan PS case. And the present instant bail application for 132 Naharlagan PS case. That's a different case. So in main case, on 27, there was a custodial assault. If my lord go through para 1, para 2, para 3, there's a clear
Even the FIR page of Naharlagan PS case number 136/23.
Yes, it is listed for hearing in item number
7 and 8.
and 8.
Today.
Yes.
Now, this matter is 4 and 5.
Yes, this is for item number 4. In item number 4, this is one of the case where just shown arrest has been done just to weaken the custodial assault complaint that has been taken cognizance by this learned judicial magistrate.
What do you have to say?
And bill ground is just
How
held
long she has been in jail?
last 48 days.
Sarsin has not been submitted.
No. So
CD receipt in this case, CD receipt. CD, yes.
What do you have to say? There are materials.
Yes. Because this accused is wanted in 4 different cases registered in 4 different police PS. So main
There's
case,
no reflection in name.
My friend
sorry.
has highlighted is about Naharlagan PS 136. And this 136 case was rejected by this honorable court in at first instance. And that is, here it is the copy of rejection order.
She is wanted in 4 cases.
Yes.
That's
For
just, my lord,
for similar
to
offense.
weaken the custodial assault only. Just subsequent shown arrest was done. Just to take custody of the alleged accused only. And the bail rejection, if my lord go through the para 14, last para, there is a clear-cut direction from this honorable court to take her into this mental hospital for further treatment. And regarding health status report is there in this bail application petition only.
Here, 3 persons were arrested
It is item number 4.
in 4, 5, and 7 and 8. In connection with this, with that case, 2 were the habitual thieves. And this petitioner, bail applicant accused, is a habitual buyer of the stolen property.
She has
And
her own
that-
shop, trading license with trading license. She run her own shop there in Naharlagan only. So there is no such that she habitual buyer or something like that. All people come there and they buy and they sell there. Nothing is like that, buying professionally, something like that.
Let him submit, please.
Yes, that article which was stolen, what crore of rupees, because it's a antique ornaments used to wear by our traditional peoples. And she knows very well which one is original, which one is just a copy or manufactured one. And she instructed the 2 thieves, arrested thieves, where to steal and what to steal. The main prime accused, that means herein is the instant accused. So she is wanted in 4 cases, and both of the other arrested accused pointed against her. That only they were working on her instruction. And regarding medical report, schizophrenia was not diagnosed. It was only just complaint made by the accused before MO medical officers. But psychosis, for psychosis is undergoing treatment. And regarding that medical ailments, that medical problems, police escort was already provided to for a routine checkup and for a taking care. Now investigation is still at national. Yes, as per all the CD today now received in different 4 cases, in all cases, she wanted specifically for further investigations.
How long she has been in jail?
She was arrested
26th of August, 26th of now.
Has she returned the articles?
There is nothing like all her shop document and all the personal loan vehicle and the ornaments, her own personal ornaments.
No, don't.
No, that's why. There was no exact seizure lease also.
No, discovery memo was
Has anything been returned?
discovery memo was there. On the disclosure of the arrested accused, this police personnel raid the house of instant bail applicant, bail accused. So many things recovers, which implicate her in all these cases, and some of the properties are yet to be recovered. This is, it will be better, Your Lordship, if we go by one by one.
Yes. We'll start with item number 4.
Yes, main case is actually item number 7,
Main case. Okay.
where this bill
We'll
applicant
take up the
application
item
was
number 7 then. Give me item number
rejected.
7. 6 and 7 also. Yes. Item number 7, yes.
that this is a, item number 7 is a subsequent bail application, which was rejected, and that copy was, I have already supplied. And for moving subsequent bail application, there has to be different ground. Only learned petitioner has taken same ground.
Same ground.
Yes. So item number 7 is not maintainable. 7.
Previously, there was no health ground. Then there was no health status being submitted before this learned court.
After considering the report from the health report issued by the doctor of the jail authority, this bail was rejected.
Earlier, there was a petition for health grounds.
There was a petition before this honorable court, but there was no not exactly medical ground. Ground was based on the
Psychosis.
not exactly psychosis. Then there was no medical report.
Then psychosis here.
No, then on that day, the day of hearing, then
Then same ground was taken.
no, my lord, one thing is
Not
to
on
be,
the petition.
yeah, not on the petition. That was not on the petition. That petition is there. So here actually the applicant is needed family care or she should be in mental hospital for proper treatment. Then only that investigation can be carried out properly. But at this stage, for last 48 days, she has been just, there are multiple cases where she has been shown arrested.
26/8, 26/9, 26/10. Same case, 26/8. She was arrested on 26/8.
Yes.
Yes. And shown arrested in the different.
Yes. Shown arrested was just to take the custody. They're just taking custody in different PS case and just taking in this same PS. In Nahalagan PS only.
So
Here is the CD item number
So
7.
now,
in this case,
Yes, item number 7.
no, this case, I think it will be better to grant bail because meanwhile, during Puja, 60 days will be over. During vacation.
Yes. Yes. By that time it will be over.
It will be over and it will be like wrongful custody. Then,
Yes.
so in this case,
That
I'm
is-
granting bail. Others, I don't know. Item number 7, heard learned counsel, Mr. For the petitioner. The petitioner has Miss Ray Amak. Post of the petitioner has filed an application under section 439 CRPC as she is in jail since 26/8/2023 in connection with item number 7, so and so PS case under so and so sections. Had Mr. G. Talo, who has raised the conclusion stating that the petitioner is a habitual offender and he has been apprehended in connection with several theft cases. It is submitted that the petitioner leads a team of miscreants who commits theft and then she buys the stolen articles, which are usually ethnic jewelry, costing around crores of rupees. It is submitted that the petitioner has come up, that the subsequent petition of the petitioner is on new ground, that she is suffering from psychosis as she was assaulted while she was in custody. So, to cover up the custodial assault, she was also shown arrest in connection with other cases, despite the fact that, with false allegation, not despite the fact, with false allegation that the petitioner is a habitual offender. I have considered the case diary. Anything recovered in connection with this case? Item number 7.
Yes. Because same modus operandi, same persons.
all of the is arrested in connection with the are taken into custody as recovered, ready to be taken. Yes. Some local ethnic ornaments, comma, one machete and cash for rupees 7,80,000 was also recovered in connection with this case. Recovered, not seized in connection with this case. The item number 7 is case number NLGPS case number 136 by 2013.
Yes.
2023, sorry. I have also considered the length of detention and the progress of investigation. I have considered the prayer of the petitioner that she will cooperate with the remaining part of the investigation. Considering all aspects, petition allowed I have also considered the mental health of the petitioner. No, mental health not required. Otherwise, it will cannot grant bail. There has to be several conditions that the petitioner cannot cause harm for herself, so and so, so and so, so. Considering all aspects, petition is allowed. The petitioner is allowed on bail of rupees 30,000, which is suitable surety of like amount to the satisfaction of the Eleka magistrate. Under the condition that the petitioner will refrain from such activities, failing which bail order will be cancelled. So 7/6. 6 is somebody else.
Same, son, based on the son arrest.
Same case.
Yes, means subsequent. Not 6, 7 and 8. 4, 7 and 8. 4, 5, 8. 4, 5, 8. Now this was 7.
So 7, this is 8.
Yes, 8. Four, 5, 8.
In connection, this is in connection with different case. Heard Mr. S. What?
T Kipa.
T. Tipa, learned counsel for the petitioner, Miss Ray Amak, who has filed an application under section. So that case number and everything you can reflect in connection with. As she was arrested, as she was shown as arrested on 20 bis law 2023. Had Mr. D. Talo, learner addition PPA. You read all the submissions I have written for both the sides. Again for learner addition PP. The learner addition PP has submitted that the petitioner is not cooperating with the investigation. So according to you, she is not cooperating with
Yes, she's not cooperating. That's why her custodial.
Several articles are yet to be recovered and her custodial detention is necessary.
Half of the stolen properties reported is not yet recovered. Half of the stolen properties which was reported is not yet recovered.
Local
And
law
one more accused is still absconding.
The co-accused is still absconding. Investigation may be adversely affected if the petitioner is not enlarged on bail. This is all part of PP, no? So 29, not even 1 month. So I'll reject this bail petition.
My lord, this is 55 Papu Hill case. This was done just to weaken the custodial complaint only. That's why. And item number 4 is also same. And item number 5 in custody. There was no reason, just, and that also assault was done by,
The magistrate.
that's why to apprise the magistrate, that still that mental status is not clear. And for, even for this bail application authority letter also, she's not signing up. So that's one of the big problem right now also. That's why at this point, she actually need the proper treatment.
This is CD pertaining to item number 7. Oh, 8, yes.
Must inform the magistrate if she is assaulted in the.
Yes, that's there in order also. Magistrate has taken cognizance. If in 55 also that's enclosed in this item number 8 also.
So this bail I'm rejecting. This bail I'm rejecting.
My lord, if you go through this page number 20 of this bail application number 98, page number 20. There is clearly that the magistrate has observed and taken cognizance by
But
state.
what does informant do now? See, she has lost.
Page number 20, first, second, from third para, page number 20. Page number 20, the order of learned judicial magistrate first class, first, second, third para. Accused person Srimati Ray Amag has stated that she was assaulted by one police personnel named SS Jha while in custody. She has stated that she was not assaulted by this. Seen injury marks on her right arm and left cheek. The medical report suggests that they are fit. Peruse the case. This record revealed that this court with order dated 27 before this production 2708 observed no injury on the accused person's Srimati Ray Amag, and she was remanded to 4 days police custody, which implies that the injury alleged was caused during her police custody. So in this regard, there was inquiry direction was given by the learned judicial magistrate against this erring police officer, that the superintendent of police Naharlagan. That's there in page number 21. Page number 21, first, second, third, fourth para. Page number 21. My lord, page number 21, fourth para, first, second, third, fourth. Accused person Ray Amag is sent to 14-day judicial custody. Authority take care of this health and safety of the accused. The allegation of custodial. Yeah.
So this in this FIR that the item the number of items that was stolen,
Yes.
the value is also not mentioned in the FIR. Items it's mentioned that local dhow, beads, ornaments, the value is not mentioned. Lordship,
But then it
Be-
may, your lordship, the value of the beads are as per our traditions.
I know it's
Original-
very expensive.
one bead cost maximum of 1 lakh, minimum of 1 lakh rupees. It's
My lord,
it's not mentioned because it has to be evaluated later on.
This varies from tribe to tribe also, because we are
So,
Arunachal, there.
the value of any ornaments is valued based on the generation. The generation, how first, second, third, fourth, fifth generation, something like that. That's a criteria how to value the ornaments in tribal society, especially according to my own understanding. So based on that, there are a number of replica also, but to value the amount of that ornaments, there is need to be a series of generation who should identify this ornaments belongs to our forefathers, like that. Otherwise, if someone bring that ornament suddenly, then that doesn't have any value in tribal society. Just its value depend on the mark of respect of their generation to generation only. Otherwise, there's numbers of agate and seals.
So she is navigating the theft according. to-
Yes,
So
Because-
recently also my order in the guest house, his also ornaments got stolen gold, not beads, gold, 70,000 rupees also was stolen. So do you mean to say that she is navigating?
no, in this particular four cases,
She's in jail now.
no, she's in jail now. In this particular four cases, all the arrested accused pointed against her. That she's the
I
main,
have seen.
yes. And their model operandi is that she used to visit, invited in the party, marriage ceremony, etc., where lady used to wear that original ornaments. And she find out who is wearing and where she resides. Thereafter, she instruct. That is all. And the tips are two different persons who only
So now she's in jail.
yes.
She has already been interrogated and now she's playing up. She's acting that she's suffering from psychosis. So what will purpose will it serve? She's already playing up now.
Yes, for
Now
the,
she will pretend that she's suffering from psychosis and she will pretend that she doesn't know anything.
for that, your lordship, this bench has already, honorable bench has already provided escort to take.
So would it serve any purpose for investigation?
Until
Yes,
it's stable,
because
it won't be served for prosecution.
discovery is yet to be done, some recovery. And absconding access. If she allowed to release on bail, maybe, or any evidence may be destroyed. If she allows to release, go on bail.
This petition I'm rejecting.
My lord,
Cannot-
there is no,
But
thing
she
is
was
that
short
all,
arrested.
yes,
Why you keep on showing her?
yes, keep on, just one more is there, just,
Yeah, the one- yeah, the-
yes. And one more is there, just we move that bail application before this learned judicial magistrate only. There's nothing such prima facie cases there.
So why are you, have you moved this application? Oh, yes, you have moved and rejected, no? This application? Or this application also rejected, yes.
No, this is a fresh application and that bail application is,
Which one has a same connection, please. So you go to the lower court first.
My
You
lord.
Do not press this petition. Please, go to the lower court first, withdraw this petition. Go to the lower court during vacation. If rejected, then we'll take up the matter.
actually,
Narayan counsel for the petitioner has paid for withdrawal of this petition. Petition will pay for withdrawal of hard Mr. G. Gallo. You named lawyers, PP for Arunachal Pradesh. The petitioner has paid for withdrawal of the petition. Matter is closed. Petition is dismissed on withdrawal. Matter is closed. So
thank you.
this will be better. The other ones will, I'll grant bail.
Same order.
yes,
Same order.
yes, same order.
4 and 5.
4 and 5, same order.
This just recently I have dictated.
Eight,
Mentioned in the other.
8, 4 and 5, same order.
Yes, yes.
Bill,
The first one which I have dictated. And this recently which I have dictated, just strike it off. Only you change the police station numbers. Send
CD,
back the CD.
yes.
First petition I have rejected.
I allow.
I have asked you to withdraw, but
Yes.
others I have allowed. So bail
Highly
is
obliged.
granted. So you can show this order and you can apply for bail in the lower court during vacation. Wait for some time, you won't be granted bail immediately. Wait for at least 10 days.
Yeah.
Highly obliged.
Highly obliged.
ये भी दे देना.
Lordship, this is on 9th of this month. It is matter as heart and length, this order of the opinion that this accused person is a drug addict, opium addicted person. Opium addicted person. This orders of the opinion that that can be granted. It's such situation.
That day I have heard you.
Yes.
Yes.
Here we received CD, LCR. And. Oh, sorry, CD.
What do you have to say?
Opium, not only opium, but it was also heroin weighing 10.78 gram.
10.71 grams.
7 what?
Intermediate quantity.
Yes, intermediate.
Last time we didn't have the LCR.
This
No.
at a appear.
I had appeared, your lordship, last time the CD was produced before the court, your lordship. However, your lordship has fixed this matter for considering his bail today.
Okay. How long have you been in jail?
Today it is 42 days.
So we'll grant him bail.
of life.
Your lordship, only with regard to our submission may be recorded, your lordship. Why? Because your lordship is well aware that it's a minimum of 60 days to 180 days, your lordship. Why I'm
But 180 days will not lie in the
Yes.
intermediate.
why I'm pressing on his bail application is that your lordship will see the CD contains that, first of all, it has being submitted by my learned counsel that
Yes, yes. He is
Kani and the heroin, your lordship. There are two aspects. He is addicted to Kani. However,
But he deals in
has
heroin.
both the heroin for 27,000 rupees to sell it, your lordship. And the person from whom he has bought the heroin, he is not disclosing the same, your lordship. That's the only issue here, because your lordship is well aware that in NDPS case,
See, just
it's
to
a
see, within this, 60 days will be over.
yes.
So it will be wrongful.
He can apply for the default bail, your lordship. There's no bar to that. There is
He
a
can apply
provision
for
under
default bail.
default bail. And also why I'm, just a second, why I'm pressing on that is, your lordship, that NDBS case, in case of drugs, it's not only of a person, your lordship. The investigation has to pull a chain from where he had bought, how it is to being circulated, because if he has bought the drugs from someone else, your lordship, that person might be selling the same to other. That is the networking in the NDPS case that has to be investigated, your lordship. In fact, Kani, your lordship is well aware that there is a proviso if he is admitted to the fact that he is an addict, your lordship. Lordship can direct him to be admitted in a rehab center. But that cannot be, since he is an addict, that cannot be a ground for his bail, your lordship. Also, your lordship, this investigation has not been completed, your lordship. The only prime accused who has sold the drugs, your lordship, he is also absconding. He is not disclosing the name of this person, your lordship. And he is admitting to the fact that he is an addict of Kani from 1998. Where-
Page 5 and 6 of CD.
He's addicted to heroin also.
Now, your lordship will see why I'm with regard to addiction, why I'm submitting is that since he admit to the fact that he has been taking it for such a long time. Where did he buy it from that point of time? He has been buying it, selling it too. He's not just an addict. He's a seller to your lordship. And therefore, your lordship will see, even if he's an addict, your lordship will see intermittent quantity, your lordship. That's for selling. He has admitted to the fact. This is a chain, the NDPS, I have already reiterating my submission, your lordship. It's a long process of investigation where the networking of such sellers and buyers are to be taken into consideration. His only cooperation with regard to,
Small flies are caught,
yes,
not the big fish.
absolutely. If the small flies reveals the name of the big fish, your lordship will see,
They won't reveal, they do not know.
your lordship, he had got a phone call. He directed, he bought it, your lordship. And in the state of Arunachal Pradesh, your lordship will see these rampant
And this area,
case
I
of,
know,
yes,
this Guntur, Guntur area,
there is
this
a,
the route,
yes,
golden triangle or golden system. It's almost like golden system.
almost half of the youth are now being an addict to the drugs, your lordship. This is a very unfortunate scenario of the state, your lordship.
So what to do?
Your lordship, that's why I'm saying that
Lordship,
45 days, your lordship,
may
he,
submit my-
if he cooperates, 60 days, he can apply for default bail. There is
Ma'am.
nothing that there is no
Ma'am.
proviso that he
Ma'am.
will not get a bail.
This is submission, first of all, submission of the PP is out of record because this is a position 21B.
No,
There
that
is-
is not
there is
also
nothing.
record.
Yeah.
She's
There's-
very much within the record.
Yes, there is nothing, it says that section 27A is not inserted in this case, first of all. Even then, lordship, my submission is today is the last court. And this, as per the seizure report, as, yes, as per the seizure report, this is, seizure is before lodging of the FIR that I have submitted yesterday, there is on the first day of my submission.
Now, this usually happens.
Yes, everything. happens.
They'll
That
see
is
that
why
and they've lost their file.
that's
That
the
is-
illegal
Yes,
procedure.
even in the
illegal
FIR,
procedure
the
adopted
date
by
of
the
seizure.
agency.
I'm just pondering about what to do. Just
Yes.
I'm thinking what to do.
That is why.
Whether to grant him bail or
Since-
whether he can, she has
since-
given a good suggestion,
since-
whether wait for default bail.
This honorable.
Let me pass over for, give me some time, let me pass over.
My only objection is prima
My-
facie, there is
my-
a case, he is not cooperating in lordship. That's it, your lordship.
Already inside the jail, inside the
You can
jail.
apply for default. bail.
Lordship, this is a poor man, addicted person, a married person.
And he has been
Having
addicted for
children.
such a long time, he refused to go to the rehab, your lordship.
And I may,
So
any order
rehab-
may be passed,
You have seen what
direction
happened
for
in rehab,
sending
one
the
person
accused
was-
rehabilitation.
one person
center.
died.
That's why, your lordship, NDPS Act, there is no proviso
One
with
person
regard.
died in the rehab, what you have seen what
Yes,
happened in
yes.
Dhemaji rehab.
Yes, recently, yes.
That is why lordship, direction may be passed for.
Person
let-
is tortured in jail is
Let him
better than
avail the
rehab.
rehabilitation
Yes.
center. Let him rehabilitate. Since he is a family man also. Out of, this is a, in absence of this man's a guilty man, this such a drug addicted person may be treated as an ill person.
Let me think over it. Give me some time.
Okay.
Deeply.
The CD is with me. I'll go to the CD. I'll think over it. Little bit, I'll think over it. And I'll decide.
Lordship, this is POCSO matter. And Lordship, now the alleged accused person has been arrested under 319, invoking 319. And Lordship,
Surety has to be a surety. Nobody has to pay.
No, bail bond amount. First condition, bail bond amount of ₹50,000.
That is something, bail bond amount. He does not have to pay. No, land, 1 kata land will be 50,000 nowadays.
No, but the learned trial court is insisting for payment. That is why. Learned trial court is insisting for payment.
In
But
cash.
In cash, my lord.
So I'll change it.
Yes.
I'll change it. Or the amount you want me to change.
The reducement. He's ready to furnish a reasonable amount, my lord, which is within his capacity.
Hard learned counsel, Mr.
R.L. Thungan.
For the petitioner and learned additional PP, Mr. G. Talo. The petitioner has filed this application under section, or not under section, the petitioner is filed this application with prayer for modification of the order of this court,
Yes,
dated 21/9/2023, whereby and whereunder a bail was granted to the petitioner.
not petitioner, no, alleged accused person,
Oh, bail was granted to the accused person. What is his name?
Siva Sonwal.
Siba?
Sonwal.
No, Sri Siba Sonwal. In connection with so-and-so PS case under so-and-so sections. The petitioner or the accused was to furnish surety of rupees 50,000, and one surety was has to be a government servant. The petitioner has prayed for the modification of this order. I have considered the submissions at the bar with circumspection. I have considered submission that if the bail, if the surety, if the order is not modified relating to the surety, the petitioner's personal liberty may be curtailed, will be curtailed. Considering all aspects, the petition is allowed, and considering all aspects, the order dated 21/9/2023 of this court in connection with BA case number what?
85 of 2020.
85 of 23 is modified to the extent that the petitioner or that the accused Sibo Sunwal may be enlarged on bail on furnishing bail bond of rupees 25,000.
Well, of 10,000.
No, not possible. 15,000. Bail bond of rupees 15,000 with two suitable sureties, two local sureties of like amount.
Well, let there be one local surety. He's from Assam. One surety he's ready to.
With one local surety of like amount. So 15,000 will be very less.
My lord, he's a daily wage earner. Does not have any regular source of income. Totally.
It is also submitted, it is also considered that the petitioner is a daily wage earner. And if the trial court insists on cash payment of surety, the petitioner will unable to pay the surety of surety, which is as high as rupees 50,000. বাকিখিনি কাটি দিয়াচোন না বাকিখিনি নাকাটি দিম থাকক দিয়ক
Yes, this other condition will remain as
the bail the
other condition.
only to that extent I have
Yes,
written
okay.
in terms of the above IS disclosed of.
I would like.
Mayor, no, just previous
Oh, yes.
item, yes, I was present. Mayor, no. It's a anticipatory bail application, Your Honor. Your Honor, the brief of the case is that, Your Honor, on dated 19 September, Your Honor, one FIR has been received at Likhavali Police Station, Your Honor. And after finding the fact that, Your Honor, that dated 19 FIR was false FIR, Your Honor. So, Your Honor, what happened here in
Before the proceed further, my lord, I suppose the informant has to be met as a party in this case in view of this judgment, my lord. Para 24. It's a judgment of full bench, my lord. Yep. And I read para 24.
So basing on after found that like Your Honor that FIR dated 19 is false, Your Honor. Your Honor, after receipt of FIR, I have been endorsed as IO, Your Honor. So Your Honor, before visited the PO, Your Honor, on anticipated, Your Honor, I have drafted a rough GD and directed writer to just not submitted in the original form, Your Honor. Just rough GD. And basing on that rough GD, Your Honor, I have been indicted in this case, Your Honor. I am the only IO, Your Honor. I am that after the endorsement of FIR only as being an IO, Your Honor, I have drafted that rough GD, Your Honor. So
You call for the CD.
yes, Your Honor. So pending disposal of this case, Your Honor, I'm highly submitted. Entry may be granted, Your Honor.
FIR is missing, no way.
Your
You
Honor,
call for the CD.
Your Honor, moreover, I'm inspector and I'm having a family, Your Honor.
No, you have to be careful.
And Your Honor, my health condition is also, Your Honor,
Call for the CD.
entry may be granted, Your Honor. At least,
No.
Your Honor, I have a family with, in fact, this puja is also coming here during this occasion, Your Honor, if I have arrested from the concern.
How did all this go missing?
And Your Honor, whether I have drafted that false CD, false, maybe, Your Honor, it's maybe a part of the departmental inquiry, Your Honor, because I'm the inspector and as being a public servant, Your Honor, it's maybe the part.
Any case goes missing, case record goes missing, what will you do? Just asking.
You know, at least, Your Honor,
CD from Likhavali police station.
Call for the CD, list the matter on 6 November.
before that, Your Honor, entry may be granted, Your Honor. Interim, Your Honor, please, may kindly. Because,
And what is this?
and
What is this?
I'm-
Rights of the victims?
Oh, no, my lord, the victim has a participatory right from the date of the commission of the offense till the culmination of the appeal. So therefore, I was.
These
my
are
lord-
fine.
Yes, my lord, but since the party is required, my lord, as in view of this judgment.
and Your Honor,
Otherwise, in POXO and all those things, there's a notification, my lord, there's a judgment.
and
But since this judgment is only for the purpose of impleting the victim and making them participate, my lord.
Victim in which case?
Informant, in this case,
Informant.
informant.
Your Honor,
But how come she is the informant? This is
If not required.
Your Honor, the fact is
No,
that,
we call for the CD.
Your Honor, both main accused is enlarged by the district and session court, Pasigat, Your Honor.
Try to delete the arrest.
Your Honor, I have submitted, Your Honor. My bail has been rejected, Your Honor. I have filed a bail application before. Your Honor, at least entry may be granted, Your Honor.